what is the GDPR? Let me introduce, Dave Snow and James Haven. James is with Dell, has been with Dell for a long time and knows this space, as well as Dave I introduced this morning with NetDocs and is in their compliance group. Okay, so again, what is the GDPR? You know, there's this comprehensive, uniform regime, and transparency, right, is the touchstone of everything. We could break it down into these other rights and all, but transparency, knowing where your data is, knowing what's going on with your data, right, that's a large part of what the GDPR is all about. Collection requires consent, and it's not just some simple consent, it's the unambiguous consent. If you heard me speaking about the Google incident this morning in my presentation, right? Not checking the box, right? You have to check the box. That is when it's unambiguous consent. Okay, so processing, and I put this up, processing is defined very broadly, so don't think about it maybe in your kind of US way of thinking about processing. It is everything: collection, recording, organizing, structuring, you know, retrieval, it's a very, very, very broad term in this GDPR regime. And so here are the sort of the criteria about the processing, right? The restrictions, right? There must be specific purpose consent, right? Specific purpose, that's what that Google decision was about, I was talking about this morning. It says you didn't really get the specific consent for that activity, that ad profiling that you were doing. You just sort of got this broad consent for all the things that Google was doing. And so that doesn't, they are reading this, they, meaning the DPOs, are reading this literally, right? Contract performance, right? So this might be something where processing is necessary to, you know, perform, you know, pursuant to some, if you're a bank or a life insurance company or something, right? So that's a different sort of processing. Maybe there's a legal obligation, right, for compliance with whatever that might be in perhaps in the regulatory space. Some sort of, you know, special circumstances, right, immediate circumstances, exigent circumstances where you have to do something. So these are the exceptions, maybe a public interest, and then there's this control or qualified need. But this is processing, and really it's the first one, and that's what caught Google and probably has caught some other folks as they're being investigated. Personal data, right? So these are the touchstones, right? Once you get beyond just transparency, right? Lawful, fair, and transparent. The processing must lawfully, fairly, and in a transparent manner in relation to the data subject. The data subject being either the profile or the actual person, however that comes about. And that's what Google, you know, was fined for, because you couldn't figure out as you navigate through all their screens and try to read all that. It was not transparent. It was anything but clear as to what Google was doing with the data. Here's the purpose limitation, right? It has to be collected for specified, explicit, and legitimate purposes. And it can't be processed beyond that. So very, very restricted. Data minimization, right? So this is a new concept, right? At least from the GDPR, it's not in the original fair information practices, which is, you know, it has to be adequate, relevant, and limited. So every time when you're inboarding, on your intake, whether it's new customers or whatever it is, employees, how much data are you asking for that you don't really need? And that's, if you're not asking that question now, you need to ask that question. Don't collect data that you don't need. And whatever you collect, you have to put some sort of a retention concept attached to that data, because at some point it needs to go away. And as we get to the right to be forgotten, on the next slide, they can ask you to remove that, right? If it's not necessary, if it's say for a loan at a bank, well, there's some data that maybe the bank needs to keep, or for the life insurance policy that the carrier needs to keep. Well, they can't ask you to delete that. But all that other data that you're asking for, probably for marketing purposes, they can say, you don't need that for that contractual purpose, take that out. All right, so that's the data minimization, which is more of a mindset, if anything, a change in mindset. Accuracy, obviously, it has to be accurate. You have to keep it that way. Storage limitation, right? We talked about that. And then integrity and confidentiality sort of goes along with the accountability principle. So here are the Bill of Rights, right? The privacy Bill of Rights that you see under the GDPR. The right of access by the data subject. So I get to know no secret database. I get to know that there is a database out there with my data in it. So that the FIP there, that's the Fair Information Principles that I put up this morning. I'm just equating the two. That's the no secret database. Article 16, the right to rectification, right? So this is the right to correct. If it's wrong, you should have the right to collect it. And those requests, we would think are starting to come in right now. And there's an arbitration proceeding, by the way, which I'll talk about later. If you opt into the Privacy Shield, there's this whole arbitration to go deal with that. So it's not so much about money and fines and that. It's about the owner of the data, the European said, you've got that wrong, or you need to change that, or you need to remove that, and you're disagreeing, and you're going to an arbitration proceeding that you're paying for if you're the processor, right? You're the controller. So you're paying for that to have this arbitration proceeding to decide, do you need to do something with that data set? The right to erase your right, that's the right to be forgotten I was just talking about. That really wasn't in the Fair Information Practices. Number 18, the right to restriction on processing, right? So that's the limited use right. You're only giving consent for a certain use and not for all these other uses. The notification, you should know, when your data is being used or changed or whatever. The right to data portability, 20, that's new. That was not under the old Fair Information Practices. And the right to object, this is about profiling. That's sort of like the right to correct. I'm not sure it's totally one for one. And the right to be free from automated decision processing, which includes this profiling. Extensive disclosure requirements, right? Who is the controller, right? You need to tell all these data the consumers that. The purpose and legal basis for doing so, the recipients, who's getting it, right? That's one of the issues with the Google fine, right? You couldn't really tell who was getting it, and they weren't saying how long you were retaining the data. If the controller transfers the data to a third country, you need to let them know about that, disclose that. How long you're storing the data, right? The right to access, rectify, erase it, and the right to lodge complaints, right? So you have all these disclosure obligations that you need to make to the European. And there's more and more. That's just some of them. That's not all of them. We talked about the right to be forgotten, right? They get to say, take that out of your data set now. There's no legal basis to continue to hold that piece of data. Data protection, right? This is accountability. You have to look at the nature, scope. Is this medical information? Is this maybe that might have a higher standard than some other information? And I know Jackie talked about this morning, Article 25, protection by design, building it in, baking it in on the front end, and it not being some, after the fact thought. Data breach notification, 72 hours. If not 72 hours, you need to explain why. And we have some exceptions, which is the one you'd expect, right? Encryption, right? So we were talking about that this morning. That's sort of the blocking and tackling now. Are you encrypting? If you're not encrypting, and I know Dave's going to talk about encryption in his systems, and maybe James as well. So the Privacy Shield, what is it? I just referred to it this morning. This is a way for U.S. companies to sort of easily comply. There's still some pains with it, but maybe easier than the full GDPR. But mainly, you shift enforcement from the EU to the Federal Trade Commission. And hopefully you're avoiding those huge fines, the 20 million euro and really the 4% of your gross, right? You self-certify to the Department of Commerce, so there's really no approval process. Of course, I have to say now, because of this latest round of when the EU renewed us under the Privacy Shield in December, one of the changes is that Federal Trade Commission is saying, if you're first time in self-certifying, you cannot say you're certified until they sort of check you out some more. So that's delaying, the process. So if you're in before, you're sort of grandfathered, although as I mentioned, they're spot checking people when they come back to renew. So the safe harbor replaces, the Privacy Shield replaces the safe harbor, which was withdrawn for some reasons we can talk about. This is the arbitration that I was talking about. You agree to this arbitration proceeding, which again, it's really not about money. It's about, is the data set right? Are you disputing the ability to change or what's in the database or correcting it, that sort of thing, or to delete it, right? The right to be forgotten. You need to do a risk assessment, and take your appropriate steps, and you must comply with the Privacy Shield for so long as you hold the data. So there's already been a few FTC enforcement actions. This where folks went in under the Privacy Shield and then said, this isn't for me, I'm getting out. And they weren't continuing to post certain information, disclose certain information. So the FTC's all over them saying, look, for that legacy data, you're in, right? You can't get out of this. So, I guess if you get rid of the data, maybe. But if you got any of that data, you're in this for as long as you have that data. So these are the, sort of the notices. You have to state the part of the privacy that you say, I am part of the Privacy Shield. You have to put this on your website. And I subject myself to the authority of the FTC. I commit to the Privacy Shield. So you've sort of now bound yourself that it's enforceable. You have to link to the Department of Commerce Privacy Shield program. You have to give information about, the type of data, right, you're collecting and how used. You have to state, the EU person can, that, hey, you say you can access your data and you can opt out of third-party disclosures. All this has to be disclosed if you want to comply, right, with the Privacy Shield, self-certify. Disclosures of choices and means to limit the use. You need a point of contact, right, so you have to have someone that the user can go to and file a complaint. And you have to have the name of the independent dispute resolution body, which could be the American Arbitration Association or others. And full disclosure, I'm an arbitrator with the AAA, so I'm not pushing them, but I'm just telling you one of those bodies will do it. And then you have to decide: are you self-certifying that you're doing all this, or are you going to bring in a third party to come in and say, you are in compliance with the Privacy Shield? So you have to say that I'm self-certifying, or I'm going to get a third party, to certify me. So I think most of this is, the verification, that's the in-house, the third party, see about the 7th bullet down, name the dispute resolution body, certify annually. And this is more than 2,500, but this is from last year. So as you know, I said this morning, there's 4,200 businesses that are in the Privacy Shield. And here is the, I think this is the AAA's. No, I think this is everybody's numbers. So if you're a company, under $5 million, you pay $250, a year into this fund, but then you still have to pay the cost of the arbitration, the arbitrators, when it happens. But this is how they're funding. So it's not a ton of money, but when the arbitration happens, you'll have more expenses. But again, the arbitrations are about the data set, not really about money. Now, the FTC, even though you've avoided those huge fines, hopefully from the data protection authorities, it's not to say the FTC, if you're egregious, isn't going to, fine you something. So that's sort of a quick walk through the GDPR. I don't know if anyone has any questions, but yep, Thomas.
So most of the discussion is focused on data that's contained in a database, so structured data.
Yep.
To what degree does the law apply to unstructured data that might be contained in, say, a PDF that's in your possession?
Yeah. Yeah. I don't think there's any different, but I'll let the
It
panelists,
doesn't differentiate.
Yeah.
If it's data, it's data. They don't differentiate from anything I've seen on the Dell technology side.
Yeah, same here. Whatever form it's stored in or compiled in, it applies. It's all data.
And that's part of the problem I've been seeing. I work on, I'm not trying to sell you a solution or anything like that today, but so you're aware. Because I work on I'm a sales engineer. When I talk to customers, the big concern is, okay, what's the one tool that's going to go into Oracle, into SQL, into PDFs, into email, into all these things to find it? And the answer is, technology-wise, there is no one thing that does all that. There's no easy button to go and find out where the data's at, and there's no then, which is the hardest thing, right? The hardest thing is, where's the data at, so I can, when somebody comes asking for it, for all these, I think that was number 15 is where's it at? Then when I go to 15, 16, 17, et cetera, those become much easier if I can do the first one, which is 15, which is where can I access the data and tell you what I've got so I can remove it. And the answer is there is no easy technology way of doing that, which is why, and you can correct me if I'm wrong, Ray and Dave, they were slow, and even now they're not really speeding towards causing a lot of fines. They don't have to, because they realize I have to create custom Oracle scripts, and your Oracle is different than my Oracle, and your SQL is different than my SQL, and your SAP is different than my SAP, et cetera. So that's what I'm seeing as far as the access and why that data, why they say if it's in a PDF and somebody was dumb enough to generate it that way, well, that's not the EU's problem. That's not California's problem. That's not Washington State's problem. They're just going to try and follow the regulation. It's up to you to figure out where it's at.
Dave, you want to?
Yeah. So even in our environment, for those of you who aren't familiar with NetDocuments, we're a document management system. And we actually do provide a framework whereby customers can, our customers, and I distinguish when I'm talking, our customers are law firms, those law firms have clients. So if I don't use those terms carefully, then it's confusing what I'm talking about. But when our customers receive information from the client, from their clients, they compile it into a document, a Word document, PDF, spreadsheet, whatever. But we give them tools that allow them to create custom metadata attributes for those documents so that they can identify, you know, does this document contain PII with simply a tag on the document. Plus, we also facilitate full content indexing for PDFs if there's a text layer in it. So we actually do provide ways for them to identify, at least if somebody comes in and says, here's my social security number, I need you to make sure that that's not listed in any of your documents. There's an easy way for them to search through that and get it. Plus, a lot of it relates to the nature of the relationship between the data subjects in this case and our customers. It's an attorney-client relationship. They know who this is. You know, the data subject actually knows what the law firm's doing with their data for the most part. And so a lot of our customers get around a lot of this stuff. But we have some interesting things we run into from our own corporate business operations that we have to deal with.
Okay, any other questions? Okay, so
Ray, before you do that, I just want to toss something. I know we're talking about GDPR. I'm actually based out of California. I don't know about you, but there's not a lot of EU businesses in California. We talk to them a lot, but I have to talk to Indonesia quite a bit, Southeast Asia. I help support things in Europe, Gulf Coast, et cetera. The GDPR just happens to be the gold standard of a whole bunch of these things. So just to kind of reiterate something, I know Ray's mentioned this before, there's other regulations. We just don't talk about the other ones because they're not the gold standard. If we can meet the gold standard, then all the other ones will fall into place, like
Right.
the California law, the Washington state law, the New York
agreed,
law, et
right,
cetera.
right. That's a good point, good point. Okay, so let's go back in time, right? So the GDPR is enacted in May of 2016, giving everyone 2 years to get ready. So let's go back, go to Dell, go to NetDoc. So sometime in 2015, something, you see this thing coming, or certainly, you know, by the spring, early spring of 2016, you know it's coming. So what happened at Dell? What happened at NetDocs to get ready for this sea change in the privacy world?
Well, we obviously had to take a look, and I can't speak to exactly when the process began on our end. I know that by late 2017, early 2018, we were in full-on sprint to make sure we were ready by May. But you know, we looked at first off, how did we match up with the GDPR's requirement for privacy by design? And we actually matched up with that pretty well because that had been our purpose from day one. We've always been an enterprise security solution. And you know, we looked at that and also at the data profiling features we've already talked about. So we thought we were in pretty good shape. Explaining to our customer base, and we have the majority of our customers are U.S. based, but we have probably 25 to 30% of our customers are actually based in the EU, so this was a significant issue for us. And helping our customers understand how our feature set met those requirements. And it was an educational process mostly. And then we also had to engage corporate counsel in the UK to help us draft appropriate amendments to our service agreements, because we play a dual role under the GDPR in that our customers are data controllers and we're data processors to a certain extent. But we also act as a controller in our relationship with some of our downstream vendors, our data centers, our network consultants, things like that. So we had to look at that entire chain and see where we needed to address our contracts and get amendments drafted and in place appropriately.
And before we go on to Dell, so any particular challenge? Can you remember what the hardest challenge might have been?
Well, probably the biggest sticking point was those Article 20, I can't remember, is it 28? The specific requirements that the data processing addendum has to contain. Some of them don't apply to us in effect because we actually can't access the content of the documents that are stored in our system. We have no knowledge at all, no visibility at all into what's actually stored. And so
Because everything's encrypted.
because everything's
Right.
encrypted
Right.
by the service before it's written to disk. And so we had to, again, educate some of our customers and explain, no, when if one of your clients approaches us and says, I want to make sure that everything my lawyer put in NetDocuments is gone, we actually have to work with his attorney, with the law firm, and actually get that done, because we can't remove it. We have no knowledge of what's in it.
You don't know what's there.
There's no backdoor
Right,
in there, so.
Right. You wouldn't know the client matter number
So,
or anything.
yeah,
right.
that's actually a way in which there's a real disconnect between the GDPR's understanding of how certain things work and the way we do business. And so that ended up being quite a bit of hurdle. In some places, it was a dead stopping point. The customers in the EU simply wouldn't sign the agreement unless we put that stuff in. And went, well, as long as we have a gentleman's agreement that you're still going to get a call if one of your clients calls us, we'll put it in. At that point, what else can we do? So.
James?
We didn't do gentlemen agreements. We made people sign contracts. Michael Dell kind of feels that way about things, I think. Before Michael Dell is somebody else. Anyway, so back in that day, I wasn't part of Dell. That acquisition was 2 years ago. I was part of a company called EMC. For those who know technology, we own VMware. If you know about virtual machines, we own that market. And some other things, RSA, security. So when they came to us, we were already been working in the compliance space. And so we kind of flipped our compliance experience with the technologies we sell. We kind of flipped the coin over to look at the tail instead of the heads. Because in compliance, particularly in the US, everything's driven by retain, don't dispose, right? Doesn't matter which regulation you're looking at, they all say that in one form or another. So we had to flip that on its head, and there were some pieces that we could take care of and some pieces that we couldn't. From a compliance perspective, files and email, low-hanging fruit because Sarbanes-Oxley, HIPAA, et cetera, were already forcing us to have technologies to help out with that. And so we were able to take that for GDPR and anything that trickles out of GDPR to these other places like I mentioned earlier, to allow us to find out what data we had. So that was our first thing that we could provide to our customers was, here's what, and when I say we know you have, we don't actually host the systems. We sell it to their IT departments, and their IT departments host the systems. So we could say, here's how you can find out what you have without ever talking to us. We don't have any backdoor access to the tools that we provide. So inside of email and files, we could very quickly help them meet that GDPR requirement. The place that we, for better or worse, we sold off Documentum to OpenText and some stuff like that. I'm sure Dave competed against them at some point. But when it came to the systems like your SQLs, your Oracles, your databases, that became not just hard, it became impossible because we'd actually sold off all the tools that would have given us access to those databases. So we actually had to end up partnering with companies like Deloitte, KPMG, in order to build more holistic approaches where we would provide one aspect of the GDPR, right? Find out what you have in that piece being able to delete what's in that piece from a technology perspective, et cetera, and then provide reports out of it. They would have to provide through a third party other tools to go into the Oracles, et cetera. And by the way, backup stream, if you're talking about technology, I haven't even talked about backup, which is a whole pain in the behind on its own. Because if you have to delete the data, you don't just delete it out of your PDF, you have to delete it out of the backup of the PDF, which is stored somewhere, and you have to hope that backup is in a place you can get rid of it, on a device you can get rid of it. If your eyes are kind of like falling asleep, that's all tech talk for it's a pain in the behind, right? And if you've switched over backup systems, it becomes even harder. So it really is an octopus or a squid, whatever you want to have, has multiple arms, and you have to be able to decide, okay, here's what's in my backup, here's what's in my backup file for database, for email, for other database, yet other database, et cetera. And so what we do with a KPMG or a Deloitte is we'll create a front end. We also have to do security. We're at a security conference. A front end ticketing system, and brought by we'll call them a fourth party, since I already used third party. So you can apply your ticket, let the ticket then be essentially manually passed to the second level, us and the third party vendors, so that we can delete that data on the back end. Because otherwise, Russia, North Korea, they would love to get in there and just wreak havoc on the back end. So that's where things become difficult, is we did not have all the database pieces, we did not have the ticketing system, but at the same time, nobody financially is worth it to go and build that. It just, no companies out there. IBM, Dell, we're going to partner with a KPMG, and so you have to build a security end to protect yourself. So there's lots of things going on. Have I confused everybody yet? Put you to sleep? If so, just don't snore too loud. Does that help, Ray?
That was great. No, that was great. Actually, that was my next question was, well, what tools do you have to help your folks get into compliance? So I guess that's part of what you were saying just now.
Talk to me afterward
Right.
for my tools.
You'll need to build something.
Well,
Right.
we'll have to build something, because I can solve part of your problem with your backups, depending on what backup you have. And if you're already doing compliance related stuff, thanks Uncle Sam, thanks Arthur Anderson, I can build part of that really without going to a third party vendor. But other stuff we'd partner with a KPMG or.
But not like there's some, like the whole solution's not on the shelf right now.
There is
Right,
no
right,
off-the-shelf
right.
solution, and I'm never seen one come out of my product managers or out of my corporate people. There's no roadmap for that.
Homework, easy's not an option.
We don't have half $1 billion just to build something that's going to change in 5 years.
You know, as I think about the majority of our customer base being law firms, I don't have any knowledge, but I'm curious to know how many of our U.S. law firms that represent folks in the EU and
Right.
our EU customers, what they've done with their retainer agreements in terms of the disclosures they need
Yeah.
to have and whether they're providing them. I get the sense, again anecdotally, that not as much has changed as should have in terms of are they really trying to comply. And I think there's a lot of law firms who might still be in for a wake-up call on the EU side.
I agree. I agree with that. Okay. So have you had anyone, now I know you don't host at Dell, but maybe assisting your clients, so there was a request to remove some data. Have you been involved in any of those episodes? Same question to you, Dave.
The answer is yes, and we say, well, we will educate you on that.
And to be clear, this is a right to be forgotten or to
Right.
correct the date or something, right?
Right,
Okay.
because this is all after the right to access, right? We have to know all that up front. So we have not gone, I can tell you the process, even though we don't send people in for, we'll just call it legal reasons. That's why we sold them the solution, so that we're not going to court. So when the solution is implemented, and when I talk about my customers, let me drop a few names here on the ground here. Citibank, HSBC, Goldman Sachs. Hopefully those are big enough names that people will trip over them a little bit. It's at Volkswagen. These are all people that have to do work in Europe. BNP, for those who want to have a little French connection there. So they've all got to do an aspect of this. When we've been brought in, the first thing that we had to do is we had to essentially develop, because at the time, this was one of the things that was hard, is we have the right, in the U.S., right, we have the need to discover and hold on to. So we had the ability to delete it, but they want to have a whole set of reports that are different than U.S. reports. So we had to go into our search tools, technology-wise, tweak out all these indexing tools that we use, and then be able to generate out, you search for James, you search for this particular piece of PII, right? Here's all the PII about James. Did you delete all the pieces or did you delete the one piece? And I need that report to be not in a big fat text file, which computer people like, but in a nice simplistic way that looks like I need to see the graph. I need to make it easy to a lawyer and to a judge who's going to roll their eyes. We had to do that with several different financial companies. And that took time. Now we're up to speed on that piece, but that just takes time. That took us time to develop, which was a hindering block. I think that took like 6 months during that process. And we were starting back in 2014, 2015 so we wouldn't be behind the curve.
Right. Thank you.
We actually haven't had a direct request from a data subject, i.e. a firm's client, asking for any kind of deletion request or rectification request. Where it's affected us is in looking at our own marketing databases and our own marketing efforts and figuring out what we've got that we can keep and what we can use. Like most of you, we keep our sales customer contact information in a CRM, and with an entire EU operation, we had to look at do we actually have consent to do anything with the information in this database.
This is you. Excuse me. This
this
is
is-
you as a business,
this is
not your
NetDocuments as a business.
not the document management
Yeah,
system.
trying
Right.
to figure
Right.
out
Okay.
how
Right. So
do
everybody.
we now,
Right.
as a business, try to comply with this, and
Right.
what do we have to deal with? And for example, our marketing team was looking at buying some mailing lists, and can you use that? How does the list provider guarantee that not only has he got consent from everybody on that list for marketing purposes, but we interpreted it, and I'm curious about your opinion on this, but they have to have consent specifically for NetDocuments to use
Right.
it for marketing purposes and for specific marketing purposes. Can we follow up with them about existing products? Can we follow up with them about new products or services we might offer? What can we use this for? And at the end of the day, none of us are used to having to get consent to that level of detail and granularity, and it's a considerable challenge in figuring out how to proceed on that with that kind of stuff.
Right. So is that unambiguous consent for that
Yeah.
specific purpose?
Exactly.
Right. Probably not, because we're just used to getting these broad consents, right? And that's in the Google decision. You can go read it. They certainly hammered them, on that point.
If the Google
Right.
decision holds, the emailing list or the marketing list
Right.
industry is out of business in Europe.
Right. They have
Unless
got
they get
a lot of curative work to do. Let's put
Yeah.
it that way. Right. Right.
That sounds good to me.
Honestly, as speaking from the individual consumer's point of view, I kind of like the GDPR. Operating a business, it's a real challenge, no doubt about it.
All right, well, that's a pretty good segue to the Privacy Shield. So we'll go back, you as a business, right?
Yeah.
So has NetDocs, have they opted into the Privacy Shield?
Yeah, we opt in and self-certify out of the Privacy Shield. And we also offer, there's something available called the standard contractual clauses that's available optionally on our service agreements, our data processing addenda to our service agreement for our customers outside the UK, outside the EU. That's becoming an issue because Brexit now, if Brexit
Right.
goes through, then we need to go back through this process again and get standard contractual clauses for all of our UK-based customers who are no longer part of the GDPR regime. And so you use the octopus or squid, it's just a never-ending thread on the tapestry.
And the
more
UK
we-
has their
Yeah, the more
privacy. They have their own privacy,
that we've got-
protection.
Yeah,
Right,
so,
right.
it's just the more we pull, the more we discover.
The more you pull, the more ink comes out, and
Yeah.
messier it gets.
Yeah, yeah, exactly.
James?
All right, I'll stop with that
Privacy
analogy.
Shield? Yeah,
We
right.
don't.
GDPR is the gift that keeps on giving. Let's put it
Hey.
It's going to make sure we're all we all have worked for a long time
Right.
to come.
We don't really work with with the Privacy Shield personally as Dell EMC. Our customers do, and we
Okay.
just help them make sure they have it. We're always worried about from a technology side, is it configured to meet the need? Because you can buy, I'll use the analogy of a car. I have a Yaris. It's great. It doesn't fall apart. But if I want it to go really, really fast, 25 feels really, really fast in a Yaris, by the way. It feels really fast. I'm going to have to change out the engine. I'm going to have to do some things. And with technology, it's the same way. You can buy anything off the shelf, but it's how it's configured to meet your U.S. compliance. And then you also have to configure at the same time, sometimes in parallel, to meet the GDPR compliance. And when we're dealing with the privacy shields or anything else, we have to make sure, have you configured it properly so that when somebody says, I need to get certified or recertified for Privacy Shield or any of these other things, that they can walk right in and you can say, I've done X, Y, Z. Here's the documentation
Okay.
to prove that I've done what I was told to do. And Dell is certified, I've certified, everybody's done the write-offs. And the government can be like, yeah, that's exactly what you need to do to meet that criteria. So we have to basically do a bunch of testing and verification with the technology to meet that need.
Got it. Got it. Any questions on any of that or other questions?
The Yaris is gray for those who are curious.
Unless you don't want to get out on the interstate, is that?
Yeah, don't go buy big trucks too often.
All right.
Push it
So,
around.
so here's.
We have a question right in the back.
Oh, okay. Pardon me. Yes. Okay. You guys want to take that one?
I know the second one.
You go right ahead. I got to cogitate on that a minute.
I don't know the answer to that first question because I don't know what Article 13 is off the
Yeah.
top of my head. The answer to that is it depends, to the second question. So for those who might not have heard it, he was asking, well, if somebody was under a retention policy before GDPR was in effect, how does it take place on the back end after it takes effect? And from a technology perspective, that's tricky. And I'll give you a very simple example. Everybody knows what Sarbanes-Oxley is, right? We all know SOX. SOX, one of the parts of that regulation says put it on a worm media, a non-rewritable media. So GDPR says, now I need you to be able to delete things off of a non-rewritable media. So the technology is designed to not let you do that. So you run into some conflicts of technology to go head-to-head with the actual retention. What we're seeing from our customers out of Europe is the auditors and the people who are asking this is best attempt, particularly when we're dealing with something that's worm-related, that has particularly financial-related. I can delete the indexes, the things that tell me how to access it, but the reality is if you were stuck with FINRA, GDPR, HIPAA, anything that kind of trailed into the database because of U.S. regulation, that data is not going nowhere. You can't make it go anywhere unless you take it and you drop it in the ocean. And then you could probably pull it out, and there are people that can actually recover that. If you're crazy, you want to do it. So they have to make allowances because some of that data is already under compliance for other purposes, and it's just not engineering-wise able to be deleted. I mean, you might be able to EMP it, but let's be realistic. We're not James Bond. We're not going to do that. So the answer is you're stuck, and you have to meet the regulations specific to that user. If some of that data if it's in the U.S. versus Europe, you're going to have to make a choice of where you're going to take your beating at. Because do I just delete the whole thing and drop my worm device? Probably not. Because then Uncle Sam gets really mad, and I live in America. I don't want to go to jail. Do I just pay the fine over there? Do I pay the fine over here? It's a tricky situation. So each one has to be taken case by case depending on which regulation you're trying to counterbalance with for that with GDPR 13.
And as far as, information and notices to data subjects before you do anything with the information, and as far as whether the Google fine's going to change, whether if they're going to turn off their websites or whatever in the EU, I don't see them doing that, but they're clearly going to have to go back through and change their privacy policies, and it's going to have an effect on whether they can continue to use that information. I don't think the fine they got from the EU at this point is enough to deter Google from doing anything. I think it's a sign that something worse is coming if they don't change. But Google's business model isn't going to allow them to change on that dime very quickly.
And a lot of folks have said, oh, that was Google and it was 50 million, but that was Google. But if you read the decision, the literal interpretation of what they're saying, it applies to everybody. They just went after Google first because, they knew they could, and they probably have an easier argument, especially because maybe it is really hard to figure out what the transparency, right, what Google's doing behind the scenes, right, just from reading all that. But, you don't have to be at Google to get in trouble if you read this decision about transparency and getting the information out and really getting that unambiguous
And
consent.
Dave was talking about that before he stepped up. Like smaller companies out of Poland, Denmark. You wanna share one of those examples?
So there's a case, actually, a ruling put down by the Polish data protection regulator just in the last couple of weeks about consent, where they'd actually been doing data scraping. And it was a database of about 6 million individuals. It included email addresses for about 1.5 million of those. And those people they reached out to and said, hey, can we use this information we've got on you? And I think the numbers, about 60% of them said yeah, and 40% of them said no. And so that's good. But the other 4.5 million, they didn't have email addresses, so they just figured it was going to be too expensive and unreasonable in their own interpretation to reach out to these people, so they didn't do it. And that's what they got in trouble for from Poland. And so where this is shaking, out, and the thing, if there's a takeaway from the rulings we've seen so far, is that the data regulators are interpreting the GDPR literally, and they're going to argue against any perceived loopholes. So there's a provision in the GDPR that says if data processing is for the public interest, then if it's like research or a charitable organization, and getting consent is too burdensome, you don't have to worry about it. Well, this company's commercial operator trying to rely on that provision, and the Polish authorities is going, no, that doesn't cover you. I think that's pretty clear that it doesn't cover you. That's how we've always read that requirement. And so, again, one commentator I read said the regulators are being truly radical in that they're interpreting this literally, which is kind of an odd thing to say. It's radical to interpret the regulation literally, but that is how they're doing it. So you've got to read it and if something seems absurd from a U.S. commercial perspective, it isn't, and you better be ready for it and act accordingly.
And I'd add to that, because I live in California with the California regulation, and I'll just get political for a second, meaning I'll talk about politics. Governor Jerry Brown just left office. Governor Newsom just came in, and Governor Newsom has kind of proven, as a side note, he said, I'm going to stop all death penalty stuff. So he's not afraid to go against the grain. And the reason I mention that is because 2 years ago, California said, we did a vote, and we said, do we want to continue the death penalty or not? And the state voted, November elections, yes, we want to continue. Governor Newsom, who just came into office, said, you know what, I don't agree with that. I don't think it's morally right. So he went against the voters. I'm expecting that to be in court. The reason that's important to this, whether or not you like the death penalty, is because out of our state, California, happened to come a senator, Kamala Harris, who was the attorney general. We have a governor, and she is very much in favor of the privacy acts. Right? She's trying to run for president. We have a governor who is willing to push back against regulations that he doesn't like. He's very pro, though, not doing things like they used to be done. And he has said he's very pro-privacy as well. So I expect that privacy regulation out of California, which does touch businesses all over the country because of how it's written, to kind of trickle out and affect other people, even people in New Orleans.
All right.
Done with politics.
Yep. Thank you. All right. Last question. Blockchain. Any experience with how blockchain? There's all these articles about how how can you correct with the blockchain and the GDPR and the conflict between GDPR and blockchain? Any experience with that in your world?
Not yet. We've done some experimenting with blockchain from a security perspective, but data integrity perspective, but we haven't done anything beyond that. It hasn't come across our radar from a compliance perspective yet.
It's a ledger. Yeah, right, because it's in the ledger, right? So
Yeah,
you're not supposed to
exactly.
change the ledger. Someone says, well, I want to be forgotten, or I need to correct that. Now, maybe correcting is a different thing, but how do you remove it all? It's kind of like your issue, with the devices, the hard media, right? So,
My answer is no.
know what?
We don't touch blockchain.
Oh, okay.
Because from a technology perspective, it's a pain
Okay.
in the behind.
All right. All right. And I have a comment, and I don't know if you guys there. A lot of these questions, when you get into the weeds on the GDPR, and you may know this, there are all these working committees that are going on all the time that are trying to deal. I bet there's some working committee that's probably trying to deal with the issue that James said. I mean, I'm speculating. So you can go find all these records are, public records. You can see what they're talking about. They meet regularly, once a quarter, twice a year or something. So you can see the issues that they're dealing with. And it is interesting not only from that, if you're trying to figure out the answer, but you see the tension between the Europeans and the U.S. because many Europeans do not like the privacy shield. They don't think the U.S. does enough about privacy, and so you sort of see that when you read these, you sort of see that tension between the participants because there are obviously, representatives, are commenting, at some of these committee meetings. So there's a whole slew of those, so you may be able to find some of your answers, there. All right, so 50,000 feet. Any comments from 50,000 feet as we close out?
I guess I would say that if there's any lesson we've learned so far, it's that the regulators are taking this literally. And in a very fundamental way, what that means is that you've really got to take the mindset to understand the GDPR, to work through your compliance efforts. You've got to understand the mindset that the people that drafted it had, that the information belongs to the individual. And that's not too far reach for lawyers because we're always used to dealing, this is our client's information, we protect it.
Right.
But in other industries, if you're a data miner or a marketing list provider or you're Google or Facebook, you've built this huge infrastructure to collect this information and you think you own it. And that's the perspective of a lot of U.S. commercial enterprises. And that's fundamentally at tension, at issue with the idea that the individual owns and should control and has rights to this data. And so I think that's the fundamental underlying tension that we still are a long way from resolving.
Good point. Good point. James?
Well, Mark Zuckerberg wants that to be sped along.
Yeah, I'm sure he'll say something
Not
else
really,
tomorrow.
not really.
Yeah.
But he'd make that his public thing.
Yeah.
50,000 feet, I would say, from a business perspective, knowing where the data's at. So, say, I would talk to IT staffs and ask them, what applications do I have? I'd provide them a list of, I have this data for this user, right? We'll just use me as an example. I've got James, we've worked with him. What systems is it in? What backup is it in? What email is it in? What database is it in? You have to make a data map first and foremost if you haven't, because until you know where the data is at, you can't meet any of the regulations. After you know where it's at, then you got to know, how can I access it? That's a different question, technology-wise. But if you can start to find out what data you have and where it's at from a 50,000-foot level, then you can start to say, IT, we need you to start doing X, Y, Z. Then you can worry about the access. Then you can worry about right of change, of manipulation, of deletion, all those other things that kind of trickle out of knowing where it's at. If you don't know it's in a file, in a tape, it's in Iron Mountain. For those who don't know what that is, that's an actual mountain where they ship tapes for disaster recovery. So when James Bond tries to blow up the world, you can get to it. I need to know about that because I need to get rid of that too. So data mapping, most important thing you could do.